Hello, my name is Hassan Ali, and the topic that I'll be presenting today is ADR and litigation. The question is the future of international commercial dispute resolution in a post pandemic world. The proposed research will aim to study the emergence of international commercial alternative dispute resolution, also known as ADR, and the techniques leading to contemporary methods in the development of a hybridized form of ADR with facilitation by courts to ensure the speedy, culturally sensitive resolution of complex international commercial disputes in a contemporary world. Now I'll be presenting the rationale in this particular presentation. Until recently, litigation and arbitration represented the only resolution techniques. The last decade had witnessed an expansion of the available techniques through the use of voluntary, non binding processes such as negotiation, mediation, conciliation, and the mini trial that take place. Educative techniques such as arbitration and litigation remain important, but executive management has begun to inquire into the efficiency of those techniques. Expanding political freedom motivates international, regional, and national support for trade and investment, and in time, business dispute mechanisms expand and gain legislative and regulatory recognition. In the past, the straightforward nature of the underlying transactions permitted a convenient framework for the dispute resolution by settlement, arbitration, or litigation. Today, the need for decent resolution of transactional business disputes has never been more important. Several recent multilateral, regional, and national developments pertaining to trade and investment and the resolution of transactional commercial disputes reflect the growing recognition of that particular importance. Today, transactional business disputes typically arise within the context of complex, long term, and often multi party relationships. Because of the enormous growth in transactional businesses, the number of commercial disputes between international parties is increasing. International commercial disputes can escalate into major trade conflicts with serious political and economic consequences. Arbitration institutions in different countries have been confronted with new challenges and opportunities at the same time. International commercial disputes, as mentioned earlier, can also escalate into many other problems. In facing booming international commercial disputes, alternative dispute resolution mechanisms underwent significant developments. The recent COVID 19 pandemic shook the world and had severe impact on all the sectors of the community. Thus, an increased need for fast and efficient resolution is needed. The efficiency and functionality of international arbitration has always been influenced by the potential intervention of the national courts. For instance, reading the New York Convention and the unilateral model law together reveals that national courts may get involved in the process of international arbitration in four separate stages. There is thus an imminent need to study the nature and evolution of dispute resolution mechanisms and propose processes that employ the best of both worlds, which is referred to as litigation and ADR, to address recent global developments and pave the way for future commercial transactions internationally. This will be the aim of my proposed research. Now, moving forward, I'll be discussing the outlines of issues, the issues that I will be discussing in my proposed research. The research will be divided into the following sections: the evolution of international commercial disputes to date and the need to employ a tailored approach for their resolution, the impact of the COVID 19 pandemic on international commercial activity and dispute resolution, litigation and its limitations in resolving international commercial disputes due to differences in cultural and legal systems, emergence emergence of alternative dispute resolution (ADR) methods as an effective tool to address disputes in a culturally sensitive manner. The advantages of arbitration, negotiations, and conciliation, citing examples from different jurisdictions, examples from various jurisdictions are to be cited, discussions on on the role of the national courts during arbitration processes, and analyze the auxiliary role of courts, particularly in granting interim relief to the concerned party. Conclusions and recommendations are the way forward to all of this. The speedy, amicable resolution of international commercial disputes through use of hybrid systems like alternative dispute resolution methods and litigation is an effective way and a tailored approach to tackle all the complex disputes in a contemporary world. Thus, the research will aim to study how adaptation of a conjoined method to optimize the value of all dispute resolution mechanisms can be created and we can process it out. I'll be discussing the research methodology, and it is divided into several parts. The first being aims and objectives of the research methodology. To evaluate the evolution of modern day international commercial dispute, resolution processes and study the need for further adoption via harmonization of ADR processes. The research will be an analytical study of published works on ADR processes for dispute resolution. It will also study the impact of recent developments on dispute resolution, including the pandemic and the evolution of dispute resolution mechanisms in different jurisdictions. This will include an analysis of whether current processes are sufficient to address quickly developing changes globally or not. Efficiency and consideration will be the main indicator to propose a conjoint approach with harmonization of courts' involvement in the international arbitration based on the comparative and analytical study of various jurisdictions. This will ensure that the findings are free from bias and impartiality and should pave the way to further development of a transactional approach for a hybrid approach in the arbitration process. Moving forward, I'll be discussing the key literatures to be considered. Although I've mentioned a number of research articles, a number of research books, and a number of research authors in my research proposal. However, I'll be mentioning a few and how it is relevant to my topic. Authors such as Nelson Stevens C., Alternatives to Litigation of International Disputes, The International Lawyer, similarly Sweet Alec Stone, and Florent Grissel, The Evolution of International Arbitration and Delegation, Governance Studies 31, 1999. All these articles and books that I've mentioned are relevant to this topic as they consider the influence that the national courts have had on the process of ADR. By this, I conclude my presentation. Thank you.